seminars together, engaging in meaningful conversations about law and philosophy. Our friendship extended beyond the classroom as we spent our formative years discovering Cambridge. Harvard Law School's academic rigor posed a formidable challenge, yet our friendship provided invaluable support, easing the journey as we navigated through the demanding curriculum. On a lighter vein, there is a quote by Charles Morgan, a British playwright, that I often think about when I look back at my days at Harvard Law School. And Charles Morgan said, if Moses had gone to Harvard Law School and spent years working on the Hill, he would have written the 10 Commandments with 3 exceptions and a savings clause. In a movie which is based on Harvard, which is very close to my heart, I've watched it several times, called The Paper Chase. The last scene of The Paper Chase is when these graduating students at Harvard Law School make paper rockets out of their marks sheets, the degree certificates, and then let them into the wind to flow into the breeze. I think I never realized the importance of that until I was reflecting on it again this morning. And I believe what it really tells us is that in this great equalizer of life and the profession, our birthmarks are surely, but surely erased, at least over time. Hillary attended, like me, Lawrence Tribe's course in constitutional law, and she was the only person in the class who got an A+ from Lawrence Tribe. Tribe became her supervisor for the SJD. As students of the SJD program, we had the best perquisite available on display at Harvard, which was we had offices of our own, all overlooking the beautiful greens. We also played our own version of the Davis Cup together at Harvard Law School. We had, as Hillary always said, a team comprising of players from Australia, India, Ethiopia, and New Zealand. But the standout image that remains etched in my memory is of Hillary on a bicycle with a little attachment to carry the groceries or to put the day's, we didn't have laptops in those days, but to put the day's working material. That reminds me always that truly, Hillary wears her scholarship and erudition with a badge of simplicity. That's truly the sign of a great human being. I have pleasure in welcoming her spouse, Dr. Charlie Guest, as well. And before I move on to a little more formal a part of my speech, I must conclude the first part, the more personal part, which is a little anecdote, which I am sure you'd forgive me for sharing on a personal note. Hillary has 2 children, Stephanie, Steph, and Will. And Will was extremely, and still is, very fond of cricket. So when the Indian cricket team went to Australia, she took special permission from the Indian High Commissioner so that little Will could go and meet the Indian cricket team at the reception for which she was invited. And a couple of days later, Hillary spoke to me and said, there's something very interesting that happened. And he just refused to go and brush. That night, when I told him as a young child, you have to go and brush and then be done for the day. And he refused to brush. So I asked him, why aren't you brushing? So he had met Sachin Tendulkar and shook hands with him. He says, you don't brush and wet your hands after you've spoken to God and shaken hands with God. Well, so much for a few personal things. Last year, to celebrate the legacy of the Supreme Court, we instituted an annual lecture commemorating the momentous occasion of its first sitting on 28 January 1950. For the first edition, we were honored to host Justice Sundaresh Menon, the Chief Justice of the Supreme Court of Singapore. This year marks a special year. It is a momentous occasion in the history of the Supreme Court and our nation. The Supreme Court of India has entered the 75th year of its inception. No one better than a judge and a scholar with years of experience and a profound understanding of the law could aptly capture the significance of this milestone. Thank you for graciously accepting our invitation, Justice Charlesworth. At Harvard, Justice Charlesworth worked on her dissertation on constitutional law from the North American and Australian perspective, while I labored over my work on affirmative action in India in the context of comparative law and jurisprudence. As we both toiled over our dissertations, we engaged with the law, but were also compelled to navigate the dichotomous yet intricate relationship between the law and politics. The theme Judge Charlesworth has selected for her lecture today, International Court of Justice, a legal forum in a political environment, is to say the least interesting and topical. It is, of course, of contemporary relevance in view of the unprecedented growth in the docket of contentious cases before the International Court of Justice. Notably, however, the theme for today's lecture also reflects a question that is fundamental to the law and legal systems, both domestic and international. The International Court of Justice held its opening session on 18 April 1946, a time when approximately a third of the world's population, including Indians, lived under colonial rule or in non-self-governing territories. As the International Court of Justice celebrated 75 years of its inception in 2021, its then president, Joan Donoghue, recognized that there has been a significant change in the composition of the court since its inception, which has impacted the functioning of the court and the diversity of cases which it is called upon to adjudicate. Today, there are 193 United Nations member states. The existence of a diverse member states community has had a tangible influence in the kind of cases that the ICJ is faced with today. It no longer deals with only questions of convention or border disputes or whaling. Not only has there been an increase in the number of cases brought before the court, the subject matter of the cases has also seen a sea change. Various nations are calling on the court to determine issues of human rights, including questions about the Genocide Convention, as we saw recently, and the Convention on Torture. In this way, the change in global politics has been crucial in shaping the transformation of the ICJ as well. It reflects the deep interplay between politics, power, and the law. Similarly, the institution of the Supreme Court of India in 1950, which we have gathered to commemorate, was also a moment that marked political and social transformation. It cannot be viewed, our founding moment cannot be viewed as divorced from the political realities of its time. The sitting of the Supreme Court for the first time echoed the aspirations of a nascent country, burdened by the legacy of colonial rule and entrenched social stratification, yet equipped with a transformative, progressive, and foresighted constitution. Over the years, the Supreme Court has embodied these aspirations by crafting a vast body of jurisprudence aimed at liberating India from its colonial past and fostering the groundwork for social transformation. In this journey, the apex court of the nation has emerged as a product of the interplay between the polity, societal aspirations, and the law. At this moment, it is important to emphasize that diversity and representation is crucial not only for rectifying historical injustices, but also for enriching the decision-making capacity of our courts. The evolving representation of nation-states before the ICJ has notably challenged its historically monocultural and Eurocentric outlook. Likewise, integrating gender diversity within the courts would substantially broaden the spectrum of perspectives, leading to more comprehensive and equitable decisions. In her book, Boundaries of the Law, Justice Charlesworth notes that in 1999, when she completed writing the first edition, international law was in a period of renaissance that was marked by the end of the Cold War between the West and the Soviet bloc, the dismantling of the Berlin Wall in 1989, which appeared to have freed international law from its political shackles. The United Nations Security Council had begun to create new institutions and adopt new thematic agendas, such as the protection of civilians and children in armed conflict. Yet, there are times that the new world order, as she tells us, may not necessarily improve the lives of women. And she says, widespread violence against civilians, including violence targeting women and girls, accompanied the new wars and ethno-nationalisms in, among others, Somalia, Rwanda, Haiti, and the Balkans. The rise in the trafficking in women and girls with opening of borders between Eastern and Western Europe, she says, and the deployment of peacekeeping troops, the increasing prominence of fundamentalist religious groups, commitment to neoliberal economic ordering, and inequalities and violence accompanying the free market zones were other signs that patterns of systemic oppression of women and girls would continue in the post-Cold War era. And then the book speaks about feminism, particularly in the context of international law. And she quotes Professor Sandra Friedman, very distinguished professor at Oxford, that what does ultimately feminism mean in the context of constitutional or international jurisprudence? And it means four things. First, the redress of disadvantage, which may require redistributive measures. Second, recognition of the prejudice, stereotyping, and violence that are caused by inequality. The third aspect is ensuring the participation of people in decisions that affect them. And fourth, the achievement of structural or transformative change, which is the fourth dimension of equality. I mention these four because we as judges and lawyers are constantly grappling with these ideas, not only in the context of feminist jurisprudence, but in terms of justice to our own marginalized, whether it's the scheduled castes, the scheduled tribes, the other backward classes, and so many other groups in our society. Therefore, from that perspective, I must, at the end, share that the first woman to be elected to the International Court of Justice was Dame Rosalind Higgins, who was also the first female president of the court. Judge Charlesworth is regarded as one of the pioneers of the feminist approach to international law and has brought this school of thought into the mainstream. She was the fifth woman to serve. She is the fifth woman to serve on the ICJ in the court's 77-year history. Recently, Judge Julia Sebutinde, the first African woman to sit on the ICJ, has been elected as the vice president. To have more women as judges of the ICJ is not the responsibility of the court alone, but a share of the responsibility must be borne by nation states and national groups who are responsible for the nomination process. I dare say the same in regard to the appointment of more women into judicial offices in India as well. I was reading that in October last year, the ICJ amended, among other documents, its rules of courts and practice directions to make their provisions gender inclusive. The Supreme Court of India has also made strides in this regard. The Supreme Court released a sensitization module for the judiciary on the LGBTQIA+ community, which seeks to sensitize members of the judiciary on concepts of gender and sexual diversity, on the usage of appropriate terminologies, and make recommendations on the protocol to be followed by courts while interacting with the members of the queer community. Similarly, the Supreme Court recently released a handbook to combat gender stereotypes in an attempt to ensure that judges use inclusive language and consciously avoid the use of stereotypes in decision-making. Before 2024, only 12 women had been bestowed with the title of senior advocate throughout the entire history of the Supreme Court. However, recently, there was a significant shift as the Supreme Court designated an equal number of women hailing from various regions across the country as senior advocates. They will be the torchbearers of change in the future of the legal profession in our society. There was once a notion of law which limited us to merely an isolated arena from society. Today, legal fora across the globe are recognizing that they cannot view themselves as divorced from the socio-political realities and aspirations of the time. This recognition fosters an environment conducive to mutual learning and exchange of ideas. I'm hopeful that the lawyers and researchers whom we mentor today, and so many of our law researchers are part of the audience, are going to change the way the legal systems have been working. The new generation of lawyers and scholars are evolving new paradigms to reimagine the conceptions of law and justice. I'm optimistic that the interaction with Judge Charlesworth will not only benefit the Supreme Court of India to learn from and engage with the International Court of Justice in the years ahead, but will inspire the young minds in the audience to reflect on finding solutions to the numerous challenges affecting the globe and our time. I once again extend my gratitude to Judge Charlesworth for gracing the Supreme Court of India with her presence, and I warmly welcome her to India. And now I yield the floor to her for the highly anticipated lecture.